10 long years.
All right, guys, we soon gonna tune in to David Otunga, former WWE talent and Harvard lawyer. He talks more about how WWE can be in big trouble with their contracts. Tune in more to the Toss Ring scandal.
I'm tired of being humble. I'm tired of letting people think they got a chance. The tribal chief is head and shoulders above everybody.
Hey guys, we're here at Toss Ring Scandal, aka KDH, at the locker room. We'll talk about David Otunga just used a legal loophole that exposes WWE contracts. Now, soon we're gonna see a video where David Otunga talks about the contracts, how's illegal what WWE's doing. Now, I saw the video. The video was so good, I had to comment on what I said to him, and I said he's been sent from God to make this video and help wrestlers out there. He commented, "Thank you, hope you enjoyed it," and share with at least one person. Thank you, David Otunga, I appreciate that. But with that being said, he talks about the Federal Trade Commission, and he talks about other things as well of how WWE, what they're doing is wrong. The whole titles of independent contractor and employee. He explains the difference between the two, and he talks about how it's just not right what they're doing and how they could be in a lot of trouble if Andrade or other people take this to court. Let's see what he had to say.
I don't want any smoke with you. I don't want any problems. But I promise on my channel, I would try to be objective. And just with everything going on, I have to cover this. I really do. Look, I'd be more than happy to help you guys rewrite this. I'd be happy to rewrite it for you. But I have to go through it as it is. So I just want to say that beforehand. Please don't be mad. How WWE's independent contractor excuse could backfire big time. Here's the thing. For decades, WWE has called wrestlers independent contractors in order to avoid paying employee benefits, taxes, health coverage. But here's the ironic thing. That same label could be the reason that their non-compete clauses aren't even enforceable. So let's break this down. I'll tell you how this could backfire legally and badly. WWE's entire system rests upon a contradiction. They call wrestlers independent contractors, but they treat them like employees when it comes to control and restrictions. And this matters because under contract law, the right to enforce a non-compete comes from employment law, not independent contractor relationships. So this seems like common sense to me. Like, if you're truly independent, the company shouldn't be able to control where, when, or for whom you work after you leave, right? Because what an independent contractor really means is an independent contractor controls how and when they perform services. They bear their own business risks, but they can work for multiple clients. And they're not bound by loyalty or exclusivity unless they're paid for it. So if WWE truly believes talent are independent, they can't restrict your outside work. They can't impose a year-long non-compete or stop you from earning an income elsewhere. This defeats the whole point of being independent. I mean, it's in the name, but all right, here we are. But WWE's own contract contradicts itself. So pulling from my 2017 WWE contract, it literally says, and I quote, "Talent represents and warrants that his relationship to WWE shall be that of an independent contractor and not an employee for any purpose whatsoever." Then, in the same contract, it says, WWE can approve or reject your performances, dictate your creative and travel schedule, terminate you for any reason whatsoever, and block you from working for anyone else for a year. Now that's not independence. I mean, clearly that's control. And in the eyes of the law, control equals employment, okay? So now, why this could backfire in court? If someone like Andrade ever challenged this in court, WWE would have a real problem because you can't enforce an employment style restriction on someone you claim isn't an employee. Employees can have non-competes if they're compensated. Independent contractors are supposed to be free to. So that contradiction alone could make the clause void as against public policy. Now, there's something else. So here's where it gets worse for WWE. If they exercise this much control, then wrestlers weren't truly independent. They were misclassified employees. Now, that means WWE could owe back taxes, benefits, workers' comp, and unemployment coverage. So either the non-compete is invalid because we're independent contractors, or WWE's been misclassifying the entire roster. Either way, it's a lose-lose. Okay, and now this is the knockout push. So the Federal Trade Commission's 2024 rule banning non-competes doesn't just cover employees, it also covers independent contractors. So even if WWE argues they're not employees, the FTC says it doesn't matter. Non-competes for independent contractors are unfair methods of competition. So basically that's checkmate. Also, there's more that most people don't know. So even if a wrestler wanted to challenge WWE's contract, they can't just go to court. Why, you ask? Because buried deep in every WWE contract is a binding arbitration clause. And it basically says that any dispute, claim, or controversy has to be settled privately in Stamford, Connecticut, through arbitration, not in open court. So this means there's no jury, no public trial, and no class actions. The arbitrator's decision is final and confidential. So if a wrestler ever challenged their non-compete or contractor status, it would happen behind closed. But this in and of itself is another contradiction. Think about it. WWE calls wrestlers independent contractors, but forces them into arbitration like employees. Independent contractors normally have the right to choose how and where to resolve disputes, but WWE removes that choice entirely in the contract. So that's another layer of control, and another reason the independent contractor label just doesn't hold up. This is kind of a legal catch-22. WWE really boxed themselves in here. So if wrestlers are truly independent, then the company has no legal right to control them with a non-compete or to force them into arbitration. But if WWE exercises that level of control, then wrestlers are really employees, and WWE could owe years of back pay and benefits. So either way, it backfires. WWE just can't have it both ways. You can't call wrestlers independent to save money, then treat them like employees when it's convenient. I mean, it's not independence, that's clearly control. And
one of the important key factors that David Otunga said, I quote, "So even if WWE argues they're not employees, the FTC says it doesn't matter, non-compete for independent contracts are unfair methods of competition." So, I mean, basically, that's checkmate. And he's talking about the FTC rule that was introduced in 2024 and explicitly wraps independent contracts into its protections. So David Otunga knows that even though that they are signed a WWE contract, you can't legally withhold them from getting work because you have them listed as an independent contractor, which we all know for independent contractor, as he explained in the video, is free to do what they want. You can't treat them as an employee and be the independent contractor because you don't want to pay taxes. So we've heard a lot of people over the years, even back when Vince McMahon was running WWE, that how they had issues with the contract with WWE and how they couldn't do anything. And then the whole thing I explained with Brock Lesnar back in 2004, that I explained in the other video, how he had to take it to court and he won against WWE as they was trying to withhold him from getting any more work. So Andrade, we're going to see what's going to happen. Is this going to go to court with Andrade? Or is it really true with the rumor? Is he really going to go back to work with WWE? As WWE is trying to avoid a lawsuit and court fees. That's why. But this is crazy, though. The whole year non-compete clause is ridiculous. I said before, it's sick. It's beyond wrong. And WWE, they better watch themselves, because in the near future, you keep treating employees like this, or as you guys say, independent contractor, it's going to come back to bite you. And I'm not just talking about one person taking it to court, be many people taking it to court. It could be a lot of stuff happening, because this is not how you should do business in any reason. Now, if you look at any other company, they're not really enforcing this year non-compete clause. It's only WWE doing this. The standard non-compete clause is 90 days, and even that is a stretch. But now a year is just way too much. But David Otunga, he literally just broke the code on this one, and it's going to be hard for WWE to answer to this one. We'll see how they respond to this at the end of the day. Other than that, though, guys, that's all I have for David Otunga. Just use a legal loophole 2 that exposes WWE contracts. You guys let me know what you think. Check out the video below of the other video with David Otunga. Until then, guys, you already know what it is at this point. It's OUT.